Hey guys, welcome to the Politics and Law class. This is the first lecture of just a few for this try. There's not too many. As you notice, I don't have a video of myself this time in the corner. Some of you have been taking economics from me and are used to that, but we'll keep it a little bit simpler this time, and I'll just do an audio voiceover. So the first lecture is what is law? And today we're going to look a little bit at some of the philosophies of law. And when we study philosophy, the word that we use is jurisprudence. It just means the study and theory of law. Scholars of jurisprudence or legal theorists hope to obtain deeper understanding of the nature of law, of legal reasoning, legal systems, and of legal institutions. Some of you may be looking at studying law in the future as well. So looking at the different schools of philosophy, we have the first one, which is law as power. And laws are nothing more than the will of those who hold power. So they might not even have been elected. They might have taken over by force. And as long as they have that force, they are the ones that are in charge. The validity of the law does not depend on whether it is socially good or bad. It's based on who has either elected you or who your friends are. It's not necessarily what's best for all of the people in your country or in your kingdom. The power to enforce its laws are central to each government's existence. Without the military or without control over some resources that maybe someone else doesn't have, then without that, someone else might take power. So you need to have control of those resources or control of a military to impose that power on others. One of the criticisms here, and we'll look at criticisms for all the philosophies here, but for this first one, law is power, the criticism, as you can imagine, might be the abuses of power, tyranny, and for producing bad law. As the picture here says, there is no greater tyranny than that which is perpetrated under the shield of law and in the name of justice. So again, not necessarily good laws are produced by this, and oftentimes those in power end up being dictators or tyrants. The second legal philosophy is natural law, and it's this law that reflects the built-in sense of right and wrong that exists within every person at birth. Natural law theory asserts that there are laws that are eminent in nature, to which enacted laws should correspond as closely as possible. Natural law is also closely associated with morality. To oversimplify its concept somewhat, natural law theory attempts to identify a moral compass to guide the lawmaking power of the state and to promote the good. And so again, the idea is that if you think about Lord of the Flies, if you've read that book or watched the movie version, the idea is, whether or not if we're trapped on an island and it's a bunch of young adolescents, would they be able to act as a society and produce their own laws? Because natural law says that they would be able to do that because we're all born within this innate sense of what is right and wrong. And so we'll be looking at something similar to the Lord of the Flies in this class after you're done viewing this lecture, and we'll do that in class sometime. Some examples of American law as far as where we see this legal philosophy: due process and equal protection laws. These are some laws that some may say are based on morality, the idea that those are disabled or those that are minorities should have equal rights. That might be part of our morals. Or due process, that somebody should at least have a trial before being found guilty. And then the tort system is just another word for our civil law system. So again, if you accidentally break something of someone else's, then it would probably make sense if you had to pay for it. And so even if we didn't have a law for that, you might do that anyway. So that would be called natural law. Now the criticism here is that when we base it on morality, the problem that you can probably think of right away is that we don't necessarily all agree about what is morally right and wrong. Just think about your classmates. You have people that might tend to be more conservative or more liberal, and their values and morals might be slightly different than yours. So there is no consensus in society about what is morally right and wrong. We could talk about stem cell research, euthanasia, capital punishment. All those things would be things that people debate. And so you can see the pictures down below there. One is on cloning and stem cell research. That would be a little odd if we had green and purple babies running around. And then the other one is has Dr. Jack Kevorkian, and I don't know if you know who he is, but he helped a lot of people with commit suicide, basically, physician-assisted suicide, people that were near the end of their lives and were in a lot of pain. He would help them and assist them in their suicide. And so you can see the cartoon there. The other prisoners there are actually scared of him because he's probably killed well over 100 people that have been documented that he's helped kill. And he was found guilty because he did tape one of the episodes, I guess. He taped it and then sent it to 60 Minutes, and then they aired it on TV, and it showed him actually, giving the shots and the things to kill the person, and then they actually saw that on TV, and so then he was convicted in a court of law. But he did that because he wanted the courts to rule whether or not euthanasia should be allowed or not, and it's still a hotly contested debate. And so that's one of the criticisms of natural law. All right, the next slide here talks about historical jurisprudence. So that is the third legal philosophy. And it says the law is only valid to the extent that it is compatible with long-standing social practices, customs, and values. Historical jurisprudence is marked by judges who consider history, tradition, and custom when deciding a legal dispute. Many of these historical events shape both morality and law. Some American laws that we might see for historical jurisprudence, this philosophy, property and contract laws. And so even if we didn't necessarily have those laws on the books, people began by making verbal agreements, and then maybe they started making written agreements about their private property. And not every country values private property, and so in America we did, and since that was one of our values, then that eventually became law. So that's an example of historical jurisprudence. And then also our Constitution. And so our Constitution, even though written many years ago, we find current legal cases every day that go to either a state Supreme Court, appeals court, or even all the way up to the U.S. Supreme Court. And so that's a document that's very old, but yet we use it and it impacts us on our daily lives. And the criticism here is determining at what point a practice has become a custom. And you can kind of see the little picture I have there on tradition, and you can just see how tradition maybe sometimes changes. And so when does it finally become a custom, and at which point then does it become a law? Is it 5 years, 10 years, does it be 100 years? How long does that custom have to last before we can see it in our legal system? All right, on to our last legal philosophy, and that is called utilitarian law. And so looking at utilitarian law basically is to maximize society's happiness. As the utilitarians measure the desirability of human contact by the amount of happiness it generates in society. They maintain that the ultimate aim of any law should be to promote the greatest happiness for the greatest number of people. So they want to maximize pleasure and minimize pain, and that is the motivation for that society to maximize that pleasure and to minimize that pain. And some examples here are if you have a penalty that is far worse than the actual crime, then future criminal actions will be deterred. Now, the problem is let's say it's shoplifting. What if the penalty was cutting off their hand? And obviously, people would not shoplift as much. So for society, that would be good. But and also might morally might be the wrong thing to do, or ethically might be the wrong thing to do. And so for the good, though, not many people would commit that crime. That kind of leads us to the criticism here. Not everyone agrees about what is pleasurable and what is painful. You have the majority opinion, you have minority opinion, and it's going to be the majority that's going to win every time. And so the minorities are not going to have their say. And utilitarians are frequently criticized for this, for sacrificing the interests of minorities to achieve majority satisfaction. In a pure utilitarian form of government, a voting majority could pass laws to even use slavery on minority groups, as long as that institution of slavery continued to satisfy the majority population. Concepts such as equal protection, human dignity, and individual liberty would be recognized only to the extent the majority of the population valued them. So you can kind of see what might be wrong there. You can see the scale there that the lady's holding. You have ethics, and then you have the people there. So weighing those different things, what's good for society and what's ethical. And that concludes our lecture on legal philosophies. And we will talk a little bit more about this when we watch a Simpsons episode in class. So bring your notes and we'll learn a little bit more about it. Have a good one.